first example consists of a case. I was not really involved in that case, but I was consulting in that case. But I really like it as an illustration of what happens when business lawyers fall into the tax professionals equality trap. In that case, there was a Chinese individual who came to a business lawyer. It was a business/immigration lawyer, and they were starting a business in the United States, and as a way for the Chinese individual to obtain his green card eventually. What happened there is they brought in an accountant who the lawyer knew for about 20 years. So the tax accountant looks at this, he says, okay, fine. The accountant knew about the FBARs at least. I don't know if FBARs are report of foreign bank and financial accounts. I said, well, okay, well, he has to file the FBARs. And then he says, well, you know, otherwise for the companies, I don't think that there is anything really particular. It's just companies. These are foreign companies. What do we care? It's about the companies. It's you know, for U.S. tax purposes, all we need to disclose is basically he knew about the Form 8938 is that they own the company, and that's it. Okay. And the reason why a lot more accountants know about Form 8938 right now is because it is part of the tax return, first of all, but second, that there has been a lot more awareness about this form, and there has been the accountants have received some training in it. So I was invited to something triggered my invitation. Let's put it this way. And into that situation, I come to this case and I realize, of course, this is not the, by this time, they already filed the tax return for 2 years, if they have filed the tax returns for 2 years. And this guy owned one company, which owned 10 other companies, which owned God knows how many subsidiaries below. So the amount of Forms 5471, and not Forms 8938, because 8938 only applies where Forms 5471 do not have to be filed. So the accountant was wrong on that issue as well. But on top of that, there are all kinds of complex rules that kicked in. A lot of these were controlled foreign corporations at these points, and the subpart F rules kicked in. So it was a huge, absolutely huge mess. So what went wrong here, right? What went wrong is obviously a wrong tax advisor was brought on this case.